Hey everyone. I wanted to I'm about to say I wanted to do this quick video. This is actually the third time I'm recording this because the first two times my microphone did not work and I cannot figure out why. So I'm having to resort to the microphone that comes with the laptop, unfortunately. So I apologize if there's any background noise or if the quality is not great. I will try and either fix mine or replace it as soon as I can. I wanted to go through, so people who have seen my video where I went through this PowerPoint, they will know some of the stuff I'm probably about to say, and I'm not going to go through it all, but I wanted to go through and just, again, highlight some of my own thoughts. The first one being that there is already privilege applied to the statements libelly made. The CRD is covered by litigation privilege, section 47B, and the New York Times article is covered by section 47D, the fair report privilege. Now, to be clear, Wayfarer have not filed their complaint based on the CRD complaint. They have filed it based on the New York Times publishing. So what is the purpose of additional privilege? What more is needed? And I suppose the question really is, the answer to that really is that with section 47.1, there's two things I see that libel is going to take away potentially. One is all the damages and punitive damages. And number two, even if she only gets attorney's fees and costs, as far as she's concerned, that's a win that she can claim under section 47.1. And, it will generate headlines because we all know what the mainstream media is like for not reading a filing properly when reporting on it and then spinning the narrative in libel's favour. And that's exactly what's going to happen. We've seen time and time again claim losses as wins. I don't know how, but she does it. And to the uneducated followers and supporters of Lively, when they hear that she's won, then that'll be that. Now, my gut feeling personally is that this is not a case that should be making a decision on section 47.1. It is a privilege that is specifically for sexual harassment, sexual abuse, assault survivors. It is a resource for people who need it, and Lively is not someone who needs it, and Lively admits that herself. I also think it should not apply where another privilege has already been applied. So Lively, like I say, has already been afforded privilege under section 47 in both the litigation privilege and the fair report privilege. And that's exactly what was in Judge Lyman's order as well. I've already applied these two privileges, so I haven't even weighed in on the question of does section 47.1 apply. But also, this should be there for people who maybe have, a lot less resources than Lively, who've maybe made their statement outside of a legal document or outside of a news reporting article, where they are being sued for defamation for sharing information, sharing their belief that they have been sexually harassed in the workplace to someone else which is not in the context of a legal filing and is not in, something like the New York Times, where neither of those privileges would apply. But here we are. And obviously we've got this in New York. We've also got Jed Wallace is sitting waiting for a decision on whether section 47.1 privilege is going to apply to him, which I think is fucking wild because he has never met Lively, clearly did not sexually harass her, and yet, he could be the kind of the first victim of this ridiculous law. I think it's a well-meaning, well-intentioned law, but it goes too far. And you end up with people taking advantage of it like Lively has, and then innocent people being caught in the crossfire. Because at its most strongest interpretation is that anyone who simply pushes back on allegations that they have sexually harassed or sexually assaulted anyone is going to fall foul of this law. And people will clearly go to court because when you say, when you accuse someone of sexual harassment, that's a very serious and very charged allegation to make. So, almost certainly people are going to sue for defamation if it's not true, if they will make you, prove your case. And if they've got evidence that you are lying, then why shouldn't they sue you for defamation? But here, Lively has had none of her claims tested because she settled her case, before we went to trial. So her damages have not been tested. Her claims were thrown out. The actual sexual harassment ones were actually thrown out, and her damages and losses were never tested. Yes, Wayfarer's claims were also thrown out. I believe some of that was not right. I think many of us do, but I don't know. I think this is just a wild situation to be in right now. So yeah, so my first issue with this is that privileges have already been applied. So what more are we adding here? If it's to add the damages, I'm having a problem with that, and I will get to why in a minute. Where is it? Yeah, so here, on this page actually, I talked about the shield and the sword, right? Section 47, which is litigation privilege and/or fair report privilege, being a shield, it protects statements and filings made in judicial proceedings. So people have a right to go to court. That's why we have litigation privilege, is to protect whatever you say. You cannot be sued for defamation for something you say in court or an illegal filing. But then Section 47.1 contradicts that and then penalises the act of filing a defamation lawsuit without good faith. But how do you know if the lawsuit has been filed without good faith? If it's not, like in the Wayfarer Lively case, the claims were thrown out on the motion to dismiss. So we never got to a summary judgment stage. We never got to trial. I have issues with this, and I did feel that it was pulling in opposite directions. And I put a little note here actually in the green box. Legal commentators, including myself, note that Section 47.1's specific enactment to address retaliatory defamation suits may signal legislative intent to carve out an exception to Section 47 broad privilege. So is this, is Section 47.1 intended as an exception to Section 47? I don't know. It was a thought I had. That's just, sorry, I am just keep going. I actually talked about the burden of proof as well. And I found 6 problems with Lively Section 47.1 claim. So, problem A, there has been no ruling on Section 47.1. So this is a case of first impression. Lyman specifically declined to opine on Section 47.1 in his order granting the motion to dismiss Wayfarer's complaint. So as it stands currently, it is entirely unaddressed by Lyman. Problem B, proven retaliation is contested. Wayfarer, are arguing our countersuit was legally legitimate. It was not retaliatory. And if the countersuit had any arguable legal basis, Section 47.1's enhanced remedies may not be available regardless of the outcome. Problem C, Section 47.1 is untested law. No appellate court has yet interpreted this statute. Courts may read reasonable basis without malice and prevailing defendant narrowly, particularly where dismissal was procedural rather than on the merits, which is what happened with Wayfarer's complaint. It was for failure to state a cause, and impermissible group pleading more than anything else. It was not really on the merits of the case. Problem D, settlement complicates causation. So the parties have settled most of their claims. Wayfarer have waived appeal rights. However, the settlement language may undermine whether Lively truly prevailed, whether the countersuit caused compensable harm, and whether damages remain legally appropriate. Problem E, the communications must be factual, not promotional. So if any of Lively's statements were embellished, formed part of a PR strategy, or were made outside the context of reporting harassment, they may fall outside Section 47.1's protected definition of communication. And then problem F. Her own expert undermines the causation argument, which I'll show you in a minute. So her own expert, Dina Maislin, included a bar chart in her report, which shows the highest negative online activity against Lively was the week she filed her CRD complaint, and the New York Times article appeared in December 2024, which was before Wayfarer's countersuit. Negative sentiment had already significantly declined by the time Wayfarer filed against Lively in January 2025. So I'll show you that. Okay. So, I haven't put a dab above it, but you can see the first big spike, the red bar. And that is back in August 2024. That is during the promotion of the film, the premiere, etc. And then after that, you can see everything died down, right? Everything died down almost immediately. Then you've got that first big spike with a pink dab across above it, yeah? That is the CRD and the New York Times article. That is by far and away the biggest week of the entire year from early May to late February 2025. That is the biggest bar, the red line of negative online sentiment towards Blake Lively. Then you've got the next one, which has got a green dab, right? It's very low down. That is when Wayfarer filed their complaint. That green dab there. That was when they filed their complaint against Lively in New York. Then you got the bar with the blue dab above it, which is when Wayfarer amended their complaint. And we got the timeline. And then you got another one further on. I put two bars next to each other because what this event actually happened in the middle of the 2 weeks. This was Lively amending her complaint. So I put an orange bar right across the page and left the three highest red bars to kind of just sit above. Everything else falls below the bar. And those three highest points are the promotion of the film, the CRD complaint, New York Times, and then Lively amending her complaint in response to Wayfarer's amended complaint. All of Lively's own actions, not Wayfarer's. So for Lively to say, well, I was damaged because of Wayfarer filing their complaint, the evidence here from her own expert does not support that. And then let's have a look. Yes, so a landmark legal test. So the court's ruling will turn on a single fundamental question. Does Section 47.1 operate as a specific statutory exception to Section 47's broad litigation privilege? Or does the privilege shield even retaliatory defamation suits from penalty? So if Lively prevails, Section 47.1 will be confirmed as a meaningful check on weaponized litigation with real financial consequences for bad faith plaintiffs. If Wayfarer prevails, Section 47's privilege will be confirmed as near absolute, significantly limiting the practical utility of Section 47.1 as an anti-retaliation tool. And the precedent, either outcome, will set a significant benchmark for retaliatory litigation disputes in California and beyond for years to come. So that is that. I'm going to just put up. Okay, so they obviously both parties filed a briefing. I'm not going to read it word for word because it's kind of self-explanatory, really. But basically, they both seem to be agreeing on the point that Lively has the burden of showing that the communication is privileged under Section 47.1a. And then Wayfarer has the burden of showing that the communication was made with malice. So they both seem to agree that's the position in terms of burden. Interestingly, Lively really does not talk much about the treble damages and punitive damages. I'm not sure how that's even going to be decided, because we never got to hear from her experts. Whether Judge Lyman would look at the reports and the depositions of the experts, that may be a possibility. But I feel like that it is just too big of a ruling, really, for him to rely on so little. If this had gone to court, then I can see the logic then of him making a decision based on, everything that went down in court, basically. But yeah. On Rule 54. Now, the thing is with Rule 54, right? Rule 54 only applies to attorney's fees and costs. It does not apply to damages, certainly not treble damages or punitive damages. But Lively really doesn't cite any authority for the treble damages. I suppose it's questionable whether she's technically waived it. Let's go to Wayfarers, actually. I found this one more aesthetically pleasing. It was such a nicer layout. So it specifically says, oh yeah, that's what Lively was doing. So Lively wants the judge to decide on things like, affidavits, declarations, depositions, etc., things that may not necessarily be on record. Wayfarer took a different approach. They wanted, things that were on record, which is sensible. Okay, question 1. Which party bears the burden of proof showing that a defendant's communication is privileged under section 47.1a? And again, they agree with Lively. Lively has the burden to show that the statement is privileged, and Wayfarer then have the burden of proving that the statement was made with malice. Let's have a look. Question 2. Whether that burden differs depending on whether the application is for attorney's fees alone or also for treble and punitive damages. Wayfarer do cite the legal standard, which is for punitive damages, which may be recovered by the plaintiff under section 3294, where it is proven by clear and convincing evidence that the defendant has been guilty of oppression, fraud, or malice. So that's the high bar that Lively would need to. I think that the damages element needs to be proven by Lively too. What else have we got? Oh yes, they do point this out as well. So I don't know if that's a typo, full or fuller. Treble damages are calculated by multiplying the compensatory damages by 3. Treble damages cannot be awarded unless and until there is a specific award of compensatory damages, which there hasn't been, there is not going to be. And Wayfarer are like, well, hold on, she hasn't claimed damages, so how can you treble her damages? I think that's an easy out for Lyman. Whether the burden differs where section 47.1b is sought, relief is sought through Rule 54 of the Federal Rules of Civil Procedure. And they're saying Lively bears the burden of establishing entitlement to an award and documenting the appropriate hours expended and hourly rates. But they also make the point, actually, that I just made a minute ago, which is that Rule 54 does not, on its face, apply to treble damages for harm caused by a defamation action or punitive damages. Hence, there is no authority establishing who has the burden of proof. So they are also saying, Judge, Section 54 does not apply to these types of damages, which is, I'm glad they pointed that out. How does a defendant discharge his or her burden on remedies provided by Section 47.1? So assuming Rule 54 applies, reasonable attorney's fees and costs are determined by motion, as they are similarly in anti-SLAPP motions, with submissions establishing the amount of the fee award and reasonable costs. Rule 54 does not provide a procedural mechanism for the defendant to prove malice or harm caused by the defamation complaint for purposes of treble damages. Since Lively has dismissed her claims and relinquished her right to appeal, there is no mechanism for her to meet her burden for punitive and treble damages. There is no authority to support the notion that a Section 47.1 motion prosecuted through Rule 54 can be used to do an end run around a plaintiff or defendant's right to a jury trial. I love that argument. So they're saying, look, Section 54, if she's relying on that, it doesn't cover these damages or these damages, and it should not be used to, as like a back door into getting damages that it does not provide. But also the fact that she has dismissed her claims means that, she can't meet her burden. You can't do an end run around our right for a jury trial. However, should the court determine that it has the authority to rule under 54 to adjudicate factual issues in a post-dismissal proceeding, the parties can be directed to meet their respective burdens in a summary judgment-like proceeding based on the evidentiary record. to determine 1. Whether Section 47.1 applies under Section 47.1. C. Because Lively held reasonable basis for her complaints of sexual harassment or retaliation. 2. Whether Wayfarer's defamation claim caused harm to Lively, which we just looked at her own expert's graph, which showed that it didn't. Compared to other actions Lively herself took, it did not, and it was nowhere near a high level of harm that, for instance, Lively's amendment of her own complaint, or Lively's, the CRD being in the New York Times. They caused so much more damage than Wayfarer filing their complaint and even amending the complaint. 2. Whether Wayfarer's defamation claim caused harm to Lively and the amount of damages to compensate for that harm. 3. Whether there is clear and convincing evidence that Wayfarer filed his defamation claim with malice, fraud, or oppression as required by California Civil Code Section 3294. So there we have it. I think that's a more logical way. I still think Lyman is reluctant to want to rule on this. I think he has given everything he's got to be reasonable, which is absolutely fine. Judges do that. I don't think he wants to be the one to set the precedent. I don't think this case, again, I will say it, I don't think this case or the case in Texas against Jed Wallace are the right cases to be setting a precedent here, especially one given that Wayfarer have waived their right of appeal. So whatever happens as in the outcome of all of this will be the precedent until another case comes along and goes further on in the judicial system. All that remains now really is for the hearing. So I'll do another video after that. I will be relying on Matthew. Is it docket updates? I'm pretty sure. We'll see what he says, and I'll just have to kind of summarize his posts on X.